My name is Brian Mayer. I'm an attorney practicing family law in Southern California. And today I'm going to be talking about what to do if the other party or other parent lies in your family law case. Now, I operate a Facebook group. It's called the Helpful Family Law Attorney. There's a link below. You can click on it. Feel free to join it. You can see the questions that people ask. You can ask your own questions. Feel free to join. Sometimes I have questions that come up that are just kind of interesting, and I look to them for potential video topics. And this question came up, and it just kind of intrigued me because it's, although I don't like to get on a soapbox, there are really two parts to this. There's what the law is and what we can do within how the law is treated. And secondly, how could the law be changed to help us get to a more just result? I'm going to start this with a story. I started my legal career in a district attorney's office. It was a medium-sized district attorney's office. We had about 40 attorneys working there. And I was responsible for prosecuting certain misdemeanor cases. And at one of my very first jury trials, the defendant's girlfriend took the stand. And when she did, she lied through her teeth to protect her boyfriend, demonstrably so. It was a certainty that she lied. And I talked to the jury afterward, and they said, yeah, she was totally not credible. We knew she was lying. It was obvious. You exposed her. It was a problem. So I took this to my boss and I said, okay, we have this person. She lied. What do we do in this situation? And his answer was interesting to me at the time. He basically said that we expect girlfriends to lie for their boyfriends. We expect husbands to lie for their wives. We expect children to lie for their parents and parents to lie for their children. It's expected. But perjury is a straight felony in California, meaning it can be prosecuted only as a felony. And it's basically, if we prosecuted everybody who lied for a family member, then half the county would be in jail. Now, this was interesting to me. First of all, perjury is the knowing, intentional, false statement of information while made under oath. That's kind of the crude way of putting it, but if you lie when you're under oath, that's about something important, that's perjury. And it's something, the explanation was interesting to me because I was new in my legal career, but I left the district attorney's office shortly thereafter, and I went into private practice. I worked for a family law firm with other family law attorneys, and I quickly began to observe that people were lying every single day in the family courts. And it was usually several people in several cases. Just as I sat there watching, even cases that weren't my own, it was clear that somebody was lying because one person would say one thing and somebody else would say the complete opposite. And there's just no way that there was confusion. Somebody was lying. And this was happening every single day, usually multiple times per day. And if you multiply that by every day, by every courthouse, and every courtroom in every courthouse in the state, yeah, you're going to end up with half of the county in jail for perjury. And it sort of creates a difficult situation because on the one hand, you have the legislature who says this is such a big deal. We're going to treat it as a felony. This means not just jail time, this means time in state prison, monetary fines. You have this crime of moral turpitude on your history forever. It's a big deal. And then on the other hand, you have the district attorney saying, well, we can't do this. There's just too many, and you know what? We kind of don't care. And to an extent, it sort of makes sense. There is a difference, the way the law is written, or there's a difference, regardless of how the law is written, between someone who is lying to protect a gang member a fellow gang member in a murder case versus a parent who's lying because they want to have more time with their child. It's just not the same thing. The consequences aren't the same. The consequences to society aren't the same. The motives aren't the same. But you still have them treated the same. And so it then falls on the district attorney's office to not only answer the question of was the law broken, but also would justice be served by prosecuting this crime, this technical crime. And the DA's offices have basically said justice will not be served by prosecuting all these cases. Furthermore, if they tried to prosecute them, if they treated all of these equally and they tried to prosecute all of them, it would completely overburden them. They'd have to look at every person's complaint who comes in saying the other person lied under penalty of perjury. They would be shut down prosecuting nothing but perjury in these family law cases, and they still wouldn't be able to prosecute all of them. So based on resources, based on justice, they have to make this decision to not prosecute it. Now, the problem with that is that it basically leaves the victims of this perjury without any sort of realistic remedy through the criminal courts to try to deal with it. So the first thing that I'll say is it is technically a crime. It can be prosecuted, but you have to set your expectations low that it's something that would be prosecuted by the district attorney's office. I'm not saying to not report this to law enforcement. I'm not saying that it will not happen in your case. Every once in a blue moon, there is something that's just so offensive that law enforcement will get involved, or the judge will refer a matter for investigation by law enforcement. It happens. It is how it is. That's, first and foremost, it is a crime and it can be prosecuted as a crime. That is always a potential remedy. Realistically, though, working within the confines of the situation, realistically, the best thing to do in most cases is to focus on using the exposure of that lie as leverage to get what you want in your family law case. Now, that can be custody time if you're dealing with custody. If a parent can be found to be lying about something related to custody, that is not in the best interest of the children, and the court can definitely consider that in making its custody decision. And in fact, if they've really been exposed, I would have no reservation about nailing that at the forefront and explaining to the court why the other party should not get the custody relief that they're asking for. If it creates any sort of extra litigation or cost related to litigation, the cost exposing that lie can certainly be awarded to you as a penalty to the other side, as a sanction to the other side. And frankly, just in dealing with the court on a regular basis, that's something I would have no reservation about just bringing up on as needed. The fact that the other side has offended the court, has tried to circumvent justice by knowingly passing on bad information to the court. They can't be trusted, and justice demands in this situation that they not be able to walk away with it. So on the civil side of things, you can do that, and so it can still give you some leverage. It's not as satisfying necessarily as getting that criminal conviction, that sort of validation with a conviction and the label of perjurer, but it's nonetheless something that can still benefit you in your case. Now, if there are any legislators that are watching this, then here's what I would like from you. Here's what I know needs to be changed in order to make this system better. Two things. First of all, the punishment for perjury needs to change. That has to change the law itself needs to change. Not all perjury is equal, and so it should not be treated equally. As I said before, there's a difference between a gang member lying to protect another gang member in a murder trial versus a parent who's just desperate to try to see their child and lies to do that. If it's not being prosecuted in the family law courts, the word is out. People know they're not going to be punished for lying, and it's happening. We need to be able to bring some sort of criminal consequence to those people, but the punishment has to fit the crime. So there either needs to be an exception in family law cases that allow for a significantly lesser punishment, or something similar to that, maybe dealing with child custody. There needs to be some sort of tool that law enforcement has available to it in order to deter the lying, to bring about consequence for lying, but in a way that still recognizes that the malicious intent is not what it might be in other circumstances where a more serious crime or punishment would be imposed. Charged or imposed. The second thing that needs to happen is there needs to be a change to allow for the prosecution of a perjury to be handled by the individual in a family law case. Now, this happens very similarly. Prosecution for contempt is treated like this. Individuals can prosecute other individuals in a family law context for contempt of court. That is, if one side violates an order of the court, the other side can prosecute them for it without going through the district attorney's office. Now, the DA's office still has the power to prosecute for contempt, but 99.99% of contempt cases are prosecuted by those individuals. And that logistically is a great way to deal with it, because first of all, when you're dealing with family law cases, as with perjury, contempt cases, the DA's office doesn't have the resources to investigate and prosecute every contempt case. There's too much to it. There are too many allegations where someone says that the other party's in contempt and they're just flat wrong, or they say they're in contempt and they simply can't prove it, and the DA's office would be eaten alive trying to investigate or prosecute contempt cases in family law family law cases. So what the legislature has done for contempt is allows those individuals to prosecute other individuals for the crime of contempt individually, taking the burden off of the district attorney's office, off of law enforcement to do the work for them. If we had something like this for perjury as well, then we would still have that deterrence. We would still have the integrity of the system would still be protected, and the resources would just be reduced to basically the court system, basically the family court system that we have now. I really don't think we'd see a whole lot of extra litigation as a result. And just most importantly, we would have that tool so that we could move forward individually, make sure that we get some justice. It could still be handled in a measured way, and we'd have just a well-defined consequence for the lies that are happening every day. And if there was that consequence for those lies, then we would probably see a reduction. There would actually be a deterrent. So that's basically, unfortunately, we're just not to that point yet. We have to work with what we've had. I discussed what kind of tools and options that we have available now. Unfortunately, it's not a lot. Maybe in the future we'll see some changes, but nonetheless, I hope that's helpful. If you enjoyed this, if you found it useful, please feel free to watch some of my other videos. Please subscribe to this channel. I will be posting more, and I will be entertaining other questions that viewers want to ask. And of course, if you actually need a consultation or representation in California, especially in Southern California, please feel free to reach out to me. I'll be glad to set up a meeting with you. Thank you. This has been Brian Mayer, and I hope that you found this to be useful.